Hi, today we're going to be discussing bumping versus seniority. Bumping simply is when a less timed employee is promoted above an employee that may have been there longer than the lesser employee. Seniority is time served with the company because you have been there for a period of time longer than other employees. In the case of Hines and Davies, we see a case where Hines, who was hired on September 15th, 1990, was there less than Davies, who had been hired on July the 30th of the year 1990. This is a case of title versus whether an employee has the skills to do the job. In the case of Ms. Hines, she was employed as a racker. At a time when the company saw the racker as an important entity in the company, they decided that Mr. Davies, whose title was saw helper, was expendable, although he had clearly been there longer than Miss Hines. The reasoning behind their termination of Mr. Davies was economic reasons or issues within the company. Mr. Davies, however, took a stance of this was done illegally against him, that he was terminated wrongly, and that the collective bargaining agreement that his union had with the company had been violated. Mr. Davies sought a grievance to be reinstated and to have his word and issues heard. So the content of this case really goes to, is his seniority valid? Should he have been given the opportunity to remain with the company and do the job of racker? Or because Ms. Hines' title said racker, should she remain with the company instead of him? When I read the case, the things that stuck out to me were the time that they both had been hired, whether or not both of them were capable of doing the job, was there support for Mr. Davies to do the job, and was there legal standing within the provisions of the contract with the union that superseded the company's reasoning for their upward movement or promotion. When I started to further investigate this case, I saw that you will see that Mr. Davies was what they called a jack of all trades. He did the odd things, the little things, the every man things of the company. He was able to relieve people in the racker position so they could go on break. These were usually 15 to 20-minute intervals. He understood the job. He had worked alongside other experienced rackers, so he understood what was necessary for this job to get done. Being the arbitrator of this case meant that I had to take that into account. I also had to look at the fact that Miss Hines had been doing the job the whole entire time. And I had to think about that because you have to give that consideration. As I continued to look at this case, I also saw that Mr. Davies had support within the company from management or managers that had worked closely with him that saw that he was capable of doing the job. That when he did the job in his intervals, he did it well and appropriately. The job did not suffer, the company did not suffer. I also looked at the fact that they stated had he had 30 days of training, he would have earned this title. He would have been put with more experienced rackers to help him further learn the position. So I had to take that into consideration. And then there was whether there were guidelines for promotions and terminations and bumpings and all those. There were. There is a Title or Article 9 provision within the company that states clearly that seniority is plant-wide, meaning that in cases of promotions, demotions, transfers, and such, that it will be done on a seniority basis. The fact that there's only 3 months that separates the two of these has no bearing on the fact of who came in first and who came in last. So I looked at that and I thought, okay, so this is in the contract. This is what was signed and agreed upon. I am sure that all employees are aware of this, including Ms. Hines. Although it may not seem fair, although it may be that she's more experienced because she does this job every day, her seniority status is not there. He has support that he is able to do the job because he has done it in his 15 to 20-minute intervals at times. So I had to think about that again and say to myself, this was definitely upward bumping that was not necessary and against the collective bargaining agreement within the company. So my decision had to be that Mr. Davies needed to be reinstated back to his original position. He needed to be given the opportunity to grant those 30 days of training so he could gain the title and do the job. So I recommended in my statement that the company reinstate him, that they give him back his job, that perhaps they should consider back pay or vacation time as a compensation for time lost, and that he should have his seniority continue from the time that he was laid off, which was a period of about 6 months he worked there when he was laid off. So giving him back his job, back pay or vacation time, and maintaining his seniority within the company were my rulings in this case. Now, there has to be a plan in place for this. The plan is, of course, to offer the job to Mr. Davies, provide the training that's necessary that obviously his management team says he is due, offer him either the choice of the back pay or the vacation time, maintain his seniority, and get him back to work. Now, there are reasons why this decision is important. All companies must maintain their union contracts. The reasoning behind these provisions is to ensure that companies have good morale and that employees understand that their companies have their backs and that their jobs are secure. It's not fair to some to see someone that comes in and does the job well, that they should lose their job. But at the same point, it's not fair if you've been there and are capable of doing the job and you have put the time into the company that you are essentially moved aside based on maybe upper management's idea of promotions. The confidence that is given here is that you keep the agreements with the union, thus there's no friction there. That you two can go into other collective bargaining situations and come up with more agreements that not only benefit the company, but also benefits the union and the employees. This was not really a hard case for me to see. I went by the letter of the law of the contract in which the union had. I didn't really take into account of titles because Mr. Davies had done the job. He had support within the company that he could do the job. That was really all that was necessary for my decision for me. Thank you for hearing my case. Have a lovely day.